So I think we're going to get started. So good afternoon, everyone, and welcome. Thank you for logging on. My name is Collier Curran, and I am the Association Manager for MACC. I would like to thank you all again for logging on today and for continuing to support MACC through these difficult times. We've been working hard behind the scenes to ensure that 2021 is an active year for MACC, both in terms of virtual events, as well as when things begin to open up. We have a lot of exciting things in store for the next few months, so please, to stay up to date, visit our website, maccny.org, so you can see all the upcoming events and register. So with the recent legalization of recreational marijuana in New York State, MACC is excited to present a webinar on this timely topic. Our presenter, Barbara DeMatteo, has prepared a thorough and informative presentation covering topics like pre-employment and during employment drug testing, New York City versus New York State regulations, and protecting against claims of discrimination. Barbara has over 35 years of human resources experience supporting businesses across many industries, so we're definitely in good hands today. Before I hand it off to Barbara, I do want to remind you that you can type any questions that you have into the Q&A function through Zoom. Barbara will be taking questions at the end of the presentation or throughout if something comes up on something specific that she's talking about. So do not hesitate to use that Q&A function. Also at the end, we can allow you to voice your question verbally if that's what you prefer. So yeah, please feel free to submit questions as you think of them. And now, without further ado, I'd like to welcome Barbara DeMatteo, Director of HR Consulting at Portnoy, Messenger, Pearl & Associates.
Thank you very much, Collier. And Collier, I'll ask you that any questions that come through the chat, let's hold them until the end. So this way we can get through the material, because I'm hoping we're going to address a lot of the issues and questions that people have during the presentation. So what an opportune day for us to have our topic of marijuana legalization in the United States, because 420 has to do with Stoner Day. I didn't know if you all knew that. So here's a little tidbit of information. How did 420 come up to be Weed Day? Well, the most credible story traces 420 to Marin, California. In 1971, 5 students at San Rafael High School would meet at 4:20 in the afternoon by the campus's statue of the chemist Louis Pasteur to partake. So we're in wonderful hands. We don't have to wait until 4:20 this afternoon, but we're kind of close. We're at 2:05 in the afternoon. So I thought that little tidbit of information might be helpful. I am very eager to talk with you about the new marijuana legislation. I know that there are lots of questions about it. And what we're going to be talking about today is this agenda. We're going to be talking about the New York State Cannabis, Marijuana Regulation and Taxation Act. We'll be talking about testing on a pre-employment, reasonable suspicion, and random basis. We're also going to talk about federal law, New York State law, New York City's law, as well as the Americans with Disabilities Act, because all of these can affect us. So let's start off with the Act, New York State Cannabis, Marijuana Regulation and Taxation Act. I'm going to call it the POD Act. It's easier. It was passed on March 31st of 2021. And what it does is that it establishes a few things. First off, it establishes the Office of Cannabis Management. So this is the board that is going to govern how everything is going to work. It's an independent agency, and it's going to be run and operating as part of the New York State Liquor Authority. Next, medical cannabis. So medical cannabis has been legal in New York since 2014. And this act allows people with a larger list of medical conditions to access medical marijuana, increase the number of caregivers that are allowed per patient, and permit home cultivation of medical cannabis for patients. Next, adult use at cannabis. So the use of marijuana and CBD oils where over 3% of THC concentration is now legal in New York. That's what this is all about. It next talks about cannabinoid hemp. It permits the sale of hemp flower in the cannabinoid hemp program. Next, it talks about tax revenue. And we're not going to get into the details, but all the cannabis taxes are going to be allocated across New York State. There is also a municipal opt-out, which is interesting. There's been a lot of conversation on Long Island about getting the municipalities to opt out of having retail dispensaries. Now, let's say Nassau County and Suffolk County or the county that I live in is going to opt out of this. It does not preclude me from driving over the border into Queens if there is a retail dispensary to buy my pot, go home and enjoy it. So nothing is really preventing anybody from getting it. Next, we talk about traffic safety. The use of pot by drivers will remain prohibited and can carry the same penalties as they do currently. Next is personal possession and home cultivation. So we're going to be able to grow our own. So those of us who are into gardening, it's time to have a little fun. And lastly, criminal justice and record expungement. So it creates an automatic expungement or resentencing for anyone with a previous marijuana conviction that would now be legal under the law. So everything is going to be gone. So what do we do with all of this information? Well, I want to start out with two very profound statements. Alcohol is legal, but an employee cannot report to work drunk. We've known that for a long time, since the end of Prohibition. In New York State, on March 31st of 2021, marijuana is legal, but an employee cannot report to work high. That's it. That's the foundation. So let's talk about how that works and how that applies to not only federal law versus New York State law and then New York City law. So let's talk about federal law first. Federal law is illegal. That's it. Marijuana is illegal. The possession, sale, or use of cannabis is a crime under the Controlled Substances Act. Now, next, in New York State, and as well as a number of other states, they've legalized medical marijuana for medical purposes. And again, New York did that in 2014. And then on March 31st of 2021, New York made recreational marijuana legal. So legal marijuana is here to stay. So let's first start talking about testing, because this whole conversation is about whether I can test or whether I can't. If you are never permitted to do applicant or pre-employment marijuana testing, our suggestion is eliminated from the panel. Get rid of it. There is no sense in testing for something that's going to give you information upon which you may take action on in the future, which you shouldn't. So that's my first rule that I'm talking about as it relates to testing. What we want to talk about is there's pre-employment and applicant testing, which many employers have been doing for many years. We want to know if somebody is under the influence. If you are going to continue to do pre-employment testing, you can do it for the other drugs on the panel. Our suggestion is take the marijuana out of the pre-employment applicant testing. So if an applicant tests positive for cocaine on a pre-employment test, you cannot hire them. But in New York, unless you fall into a specific category, which we're going to get into momentarily, in New York, if you do a pre-employment test and you test for marijuana, you can't take any action on it. So don't even include it. I don't know if there's an extra fee for it, but why pay for something that you're never going to use? Next, reasonable suspicion testing. Every employer can do reasonable suspicion testing. We're going to talk about some of the behaviors and symptoms that might be coming along, which gives you reasonable suspicion that an individual is under the influence of drugs and or alcohol. And after an interactive dialogue and conversation with the person based upon what you've experienced and seen, then I would arrange for a drug test. We'll talk about that in just a few minutes. Lastly, random testing. Random testing is now going to be limited again because it gives you information about potentially an individual having pot in their system, which is not currently affecting their ability to do their job, and we won't be able to take action on that. Up until now, I've seen very few employers, unless they're regulated by a certain federal or a federal law or a contract, I've seen very few employers do random testing. Mostly it's been pre-employment and reasonable suspicion. So when we talk about, now that we've talked about just simply testing, now let's get into what the rules say. Let's first start talking about federal law. And I'm talking about the Drug-Free Workplace Act. And why am I talking about this? Well, because it requires federal contractors to establish a drug-free workplace in order to qualify and maintain a federal contract or grant. And this includes subcontractors and subgrantees. The reason why I'm mentioning it here is that a number of you may be a subcontractor under a federal contractor, meaning that you have to abide by these rules. Whether or not you fall under this act is up to you to determine. After this call, and at any point in time in the future, our staff here is always welcome to help you through this conversation, to help you determine if you are either a contractor or a subcontractor. But let's go under just a few regulations and rules that the Drug-Free Workplace Act requires. So what employers have is they have obligations to post a policy and take appropriate action if an individual has been tested positive. So remember, I'm not talking about New York State, I'm not talking about New York City. I'm saying if we're a federal contractor, we abide by federal law, and marijuana is illegal under federal law. So here you can test on an applicant, reasonable suspicion, and random basis. If you fall under the Drug-Free Workplace Act, you have responsibilities to make sure that you are then notifying a contractor if an employee tells you that they have been convicted of a drug offense. And employees have obligations to report drug convictions within 5 days to you. So there's a couple of moving pieces here. So what's going to happen if you don't identify yourself in this way, or you don't pay attention to the rules? Well, if the federal government finds out, they can cut your contract, they can blacklist you, they cannot pay you. So there's lots of things that the federal government has in terms of power to make sure that whoever this applies to is paying attention to it. So please find out if you're a federal contractor or not. Now, just as a sampling, I went online and I found just a partial list of top contractors in New York City. And now this list is from 2018. There's only a list of 10 here. There's many, many more. But we need to take a look and see, well, who are the top contractors here that at least I'm familiar with? I'm familiar with Tishman, Turner, Skanska, JT Megan. If we are a subcontractor to any of these organizations, we fall under the Drug-Free Workplace Act, Drug-Free Workplace Act, and we can be a subcontractor. So please find out if this applies to you or not. It's really an important piece. Okay, now let's talk about a second aspect of federal law, which is from the Department of Transportation. So again, federal law says that marijuana is illegal. So if an individual is in a safety-sensitive job, which includes but is not limited to bus drivers, truck drivers, train engineers, subway operators, airline pilots and crews, and ship captains, under federal law, because under the Department of Transportation, you can test on a pre-employment and random basis, as well as reasonable suspicion. And then you can take appropriate action, because the federal government says you can do this. Now, the most common drug test that's administered to truck drivers is the 5-panel drug test. You may want to take a look at what your testing arrangement is with your testing facility. And typically, the test checks for THC, which is the tetracannabinol, I know I'm going to pronounce it right. Let's use THC, that's pot, opiates, PCP, cocaine, and amphetamines. And if you are a DOT-regulated employer, you have to comply with the applicable training, testing, and the training requirements. Now, let's understand that the Department of Transportation does not allow somebody who is on medical cannabis to be a valid excuse for a positive drug test by an employee. So they're not going to accept that. So for employers who are subject to the DOT rules, the marijuana prohibition for medical or recreational use overrides any state law. If you need help determining if you are under the Department of Transportation rules, please call us and we are happy to help you. Okay, so those are the rules under federal law. So it's all about, do any of these apply to me as a contractor and as a business? Now let's talk about New York state law. You can and should have a complete and comprehensive no tolerance policy, and you should prohibit marijuana use or possession during work hours, at the workplace, and while using an employer's equipment or other property. This is the simplest, no tolerance across the board. No ifs, no exceptions, no maybe, but if. No, but you know, you're a really good guy. No, but I really like you as an employee, but I don't like you as much, so I'm going to apply it to you and not to this one. That can be very simple grounds for discrimination claims, which we want to completely avoid. And you've heard me talking about that for all of our meetings. When you are going to have a no tolerance policy, it has to be consistently applied to everybody who is an employee. And remember, reasonable suspicion testing can always be done according to federal, state, and New York City rules. Okay, now let's talk under New York State. There are only 2 safe harbors that they give us, meaning that employers can take adverse action against employees who engage in off-duty marijuana use if the employer is subject to federal laws. Now, let me back up here. When an individual is under the influence of alcohol, or we believe that they're under the influence of alcohol, we send them for an alcohol test, and we can tell, the tests tell us whether the person is not able to work, okay? Because there's the blood alcohol level. So that's nice and clear. Right now, it hasn't been publicized yet, but there is right now no test out there which talks about if I have marijuana in my system, is it affecting my ability to do my job? The tough thing about THC is that it stays in a person's system depending upon their size and weight and how much they eat and drink during the course of the month, but it stays in a person's system for 30 days. So if I took marijuana and smoked it, or maybe it was in my grandmother's brownies 30 days ago, okay, it's still going to be in my system. But it doesn't mean 30 days later that it's affecting my ability to do my job. I hear of many people who, as soon as they walk out of the office, they go home, they do their marijuana in whatever way, shape, or form. By the following morning, it's gone, and they're able to come back to work and do their jobs. So it's going to be in my system. That's why it doesn't give us the ability to test on a pre-employment basis, because you don't know if it's affecting somebody. So let's go back to these 2 safe harbors. You can take adverse action against employees who engage in that off-duty marijuana use if you're subject to federal laws and you're required by federal law, regulation, or ordinance, or a mandate in order to do testing like we talked about before, say Department of Transportation, or if complying with this act is going to require you to violate a federal law or will result in the loss of a federal contract or funding. So these 2 safe harbors are very specific, and that's the only thing that you've got. We have to remember an employer cannot discriminate against employees using marijuana just because it is illegal under federal law. It has to tie to obligations under federal government contracts or grants. Okay, next, let's talk about workplace impairment. Here's where the reasonable suspicion comes into play, and here's some certain language that I want to talk about in the New York State law. Employers can prohibit and take adverse action against marijuana users based upon an employee's impairment in the workplace. This is the reasonable suspicion that we talked about. New York State law uses this language. They say when an employee displays specific articulable symptoms while working that decrease or lessen the employee's job performance, or such specific articulable symptoms interfere with the employer's obligation to provide a safe and healthy workplace that are free from recognized hazards as required by OSHA and state safety laws, reasonable suspicion testing can take place and adverse action can be taken. So here, this is reasonable suspicion. And this is something that I need to observe. It is not something that you're going to be based on hearsay. So if I am seeing, another manager is seeing an employee acting differently than their normal behavior, suddenly there's delayed reactions, there's poor coordination, they're stumbling, they're slurring their words, not making sense, red eyes, dilated pupils, sleeping, giggling, laughing, whatever it may be, there's an odor of marijuana, all of these things around all of this. These are reasonable suspicion and articulable symptoms that you can now ask about. And the sooner you ask about this, the better. Because remember, even though pot may stay in my system for 30 days, I'm saying that it's not going to be in my system tomorrow. So all of these articulable symptoms are going to be gone tomorrow. When you are looking at these behaviors or when you become aware of these behaviors, they should be objectively documented by at least two people who witness it. It should not be based on hearsay because we know what hearsay is all about, right? So let's say you have somebody in the field and you're in the office and your foreman or your super, somebody calls and says, you know, Barbara seems that she's acting very oddly and I'm smelling pot around her. Well, we all have the advantage of having our phones, get a Zoom call, get the employee and that manager, supervisor on the phone with you. So this way you can make a decision right then and there. You're going to have a conversation with them. And I'm going to give you the talking points for those conversations in just a little bit. But don't just base it on hearsay, because then if you are going to send a person for a reasonable suspicion drug test, you should make arrangements to have that individual sent for that drug test instead of putting them in their own car and having them drive there. First off, they may never get there. And second off, you don't want to take the chance on them getting it, God forbid, into an accident. And now it's your responsibility to respond to that. Okay. Now, next, under New York state law, this is the last piece. Driving while impaired is not protected, never was. So if during the course of employment, whether an employee is driving a personal vehicle or a company vehicle, and the company is made aware of the use of pot, the company can conduct reasonable suspicion testing and take appropriate action. So that's a lot of information on New York State and the federal law. Now, I want to go through a couple of case studies if I could. And I want to say, let's use this example. A forklift driver is driving erratically and runs into a wall. Well, I think that this is an articulable symptom. I think we have a problem here. So what guidance do we give here? Now, the guidance that I'm providing here in terms of these steps, I'm going to be sharing with Collier after our workshop today, and she's going to be emailing this all to you. So you don't need to take copious notes on what this is saying. I'm going to be getting it to you all in writing. So here's a case study. The first thing that you need to ask if somebody drove into a wall with a forklift is could this be an articulable symptom? And I would think so. Does it give reason to believe that there may be substance use? Yeah, reasonable belief. Could be something else too, which we're going to ask about. So now you're going to talk with the employee, not at the employee, with the employee. This is a conversation. You pull them into an office, have them sit down in front of you, and you're observing their behaviors. First off, state what you observed. Or if a manager saw this, bring that manager in and say, what did this manager observe? Ask the questions. What could be causing the behavior? You never know what you might find out. It may not be drugs. Ask if there is a medical emergency. We had this situation once, and sadly, the employee was suffering a stroke. And if there is, God, you send 911 right away. Ask if they took a prescribed or over-the-counter drug. We all know that there are plenty of drugs that are either prescribed or over-the-counter that make us a little woozy. Ask if they smoked marijuana or took any other drug that's affecting their ability to do their job. And then arrange for that employee to get a drug test. And they should be suspended until you get the results. So unless you're hearing it's a medical emergency, unless you're believing that it is something else that is other than drugs, send them for a drug test. It's your safe place to be. No one needs to know about it. Make arrangements to have the employee get brought to the testing facility. And no, we do not suggest having another employee drive them. Could you imagine? I had one employee drive another one, and the employee who was under the influence of drugs suddenly got into a fight. They almost got into an accident. And the employee who's driving them doesn't deserve that behavior. So send for an Uber or send for a car service. And lastly, it could result in termination of employment, but make sure that you are following the company policy and be consistent. Now, typically you're going to get responses and results of your drug testing within 24 to 36 hours. If it comes back and it is positive, meaning that there was drugs in this individual's system, if you're going to take a stance on a no tolerance policy, fire them. If you're not going to be consistent with your no tolerance policy, then you got to be careful as to how you're handling it, because how you handle the prior employee is setting the precedent for the future. And setting precedent and making exceptions to the rules is all what results in discriminatory claims. So be very careful there. When you have an issue like this, call us. We can help you through it because these are sensitive issues and we want to make sure that we're giving you the right information. If the employee refuses to take a drug test, they refuse to go. I'm not going. I'm not getting it done. Then you arrange to have them sent home. And then that can also lead to disciplinary action up to and including immediate termination of employment because you have a no tolerance policy and practice. And that should clearly be in your policy. Okay. Next, your truck driver arrives to the work site and you smell pot. He denies use and claims it was a passenger who smoked in the vehicle. Goodness, what do you think we should do? Let's go to the same list. You see how it still applies? Ask the questions. Don't make an assumption. You're still going to ask if it's a medical emergency, whether you smell pot or not, whether they are pointing fingers at somebody or not. How about this situation? Your bookkeeper is suddenly slurring her words, giggling, blatantly inaccurate in her work. Something is very different today than it was yesterday. What are you going to do? You're going to go to the same list. Could it be an articulable symptom? Could it be a medical emergency? Could it be something else that's going on? Take the same action. If you have a no tolerance policy, behave that way. If you're not comfortable having a no tolerance policy, then you really have to document how you've handled prior situation and each situation because that sets the precedent for the future. And those of you who have heard me speak in the past, you know that it's very easy for me to file a discrimination claim, even if you're intending to discriminate against me or not. All I have to feel is that, oh, you didn't treat him the way that you're treating me. I guess it must be because I'm a female. I must be over 40. Let's see, I got a back issue and give me a little bit more time and I'll come up with something else. So it's very easy for me to file a discrimination claim. And then all you have to do is go through the time, the effort, the energy to investigate it and the money to respond. I'd rather you spend your money on developing your team and hiring people. Okay, wait a second. We forgot about New York City. Well, no, we didn't forget about them. But let's talk about what happens in New York City. Effective May 10th of 2020, the New York City Commission on Human Rights amended its rules to add exceptions to the general prohibition on pre-employment testing for THC or marijuana. So, well, what does that mean? Well, the exceptions to this rule, okay, say this. And which of these are going to apply to you? I'm going to bet maybe one, maybe two, but it may not apply to 100% of your team. So you can test if the position requires that an employee regularly or within 1 week of beginning employment works on an active construction site. Okay, so this is going to be your laborers. This is going to be your apprentices, your supervisors, your foremen. It can apply to your project managers who are on your active construction site ongoing. It can be applied to somebody on the senior management team who is checking in on what's going on at the construction site. Here's the next one. The position requires an employee regularly operate heavy machinery. Well, that may not apply to all of us, but it might apply to some of us. The position requires an employee regularly work on or near power or gas utility lines. That might apply to some of us, maybe not to all of us. The position requires an employee operates a motor vehicle on most work shifts. Now, this does not apply to my commute to and from work. This applies to I am working during the course of the day and I need to travel from job to job in the company truck, in the company van. This could apply to that project manager who is visiting different sites in order to manage the projects. It could be your business development person who is traveling to and from sites in order to make and present quotes and proposals. It can involve your salespeople, but I highly doubt it's going to apply to your accounting staff or your receptionist staff. So it depends upon the job. Next, I do not believe applies to you. It has to do with fueling an aircraft and working around aircraft. Or the last might apply. Impairment would interfere with the employee's ability to take adequate care in the carrying out of his or her job duties and would pose an immediate risk of death or serious physical harm to the employee or to other people. So if you're not sure if the rule is going to apply to you from a New York City perspective, call us. We can help you. Now, the New York Citywide Administrative Services has given you some help. The commissioner has actually come up with a list of titles for which pre-employment testing for THC and marijuana are permitted. Now, the list is probably about, 50 to 75 titles. And when I flipped through it, I just picked up these three, which I believe apply to our business: an apprentice, a construction laborer, or inspectors. So the link at the bottom is where this list actually is. I strongly suggest that when I send this over, or you're taking notes on that right now, or you're seeing it right now on your screen, that you see which of your jobs is going to apply, which of the titles is going to apply. And please don't kind of start making up titles for people just to do pre-employment testing, okay? But that's a very simple and easy way to find out if this is going to apply to you. New York City has done a great job of providing us with information. Okay, so let's summarize. All employers can test for reasonable suspicion. I can only continue to repeat to you that you have to be consistent in how at least 2 managers have identified those articulable symptoms, those reasonable suspicion symptoms, that it's very clearly documented, and then the employee is sent for a drug test. And that documentation should not be, well, I just know that he smoked pot. No, it should be, here are the symptoms. He is slurring his words. He's dizzy. He can't work a straight line. He's not attentive to his work. He can't answer any questions. He used, his cell phone to try to change the channel on the television in the break room. You want to write down the actual behaviors behind it, not your opinion. Next, marijuana is illegal under federal law. So if you're subject to federal law, you can drug test for applicants' reasonable suspicion and random drug testing. That's real clear. Determine if you're subject to the Drug-Free Workplace Act, because this can affect you as a federal contractor, whether you are a federal contractor or subcontractor now, or whether you may be a federal contractor or subcontractor in the future. You need to know what your obligations are. Determine if any of your jobs are subject to the Department of Transportation rules, because these are very, very clear. And these are all under federal law. So remember, marijuana is illegal under federal law. That's why it allows for testing and certain actions to be taken. Next, marijuana is now legal under New York State law. You can do the applicant testing, but don't take adverse action because of a test. So eliminate it from the panel, just like we talked about before. You can take adverse action because of a positive test on the rest of the drug panel. The most typical out of the 5 are opiates, amphetamines, cocaine, and PCP. If you want to add others to that, talk with your drug testing facility. But if you're not, and you cannot use applicant drug testing results, don't even ask for it. Don't even do it. Don't even see if there's marijuana in my system or not. Testing in New York City. Applicant reasonable suspicion and random testing is legal under certain rules for specific positions, and then you can take adverse action for a positive test. So this is quite the summary here. Zero tolerance is your best policy across the board. Don't tolerate it. Become known as an employer. Develop that brand that you have a zero tolerance policy. You have a zero tolerance policy against sexual harassment in the workplace. Have a zero tolerance policy against drugs in the workplace. It's going to be the easiest for you to manage and easiest for you to defend. Oh, what? Hold on, before we finish, there's one more thing. We need to think about the Americans with Disabilities Act. Because we need to recognize that when an employee is under the use of medical marijuana, they are certified to treat it as a diagnosed medical condition, and they are considered to be and defined to be disabled under the Americans with Disabilities Act. So under the ADA, if an individual is using illegal drugs, they're not qualified to be disabled. Under the ADA, if I am in treatment for my addiction, I am protected against termination of employment and adverse action taken against me. But if I was in treatment and I ended my treatment, the first day I have a glass of alcohol and I am on the job, or I take some drugs, which includes marijuana on the job, you can take adverse action against me. So what we need to think about, let's go back to the ADA. It's a federal law that prohibits employers from discriminating against those with disabilities. And we have to make an accommodation as long as it's not an undue hardship and it doesn't affect a safety sensitive position. And your requirement is to engage in what we call an interactive dialogue. So this means a conversation with the individual. This doesn't mean a conversation at saying, okay, I guess you're disabled under the ADA, what do you want? And we're just going to go there. It's an interactive conversation, which can take place on a few occasions. Now, under the ADA, we're required to have an interactive dialogue. And under the New York City human rights law, which is where we're working, they impose a higher burden on employers regarding workplace accommodations. Whereas most of the discrimination and accommodation laws are just going to talk about an interactive process, the New York City human rights law talks about a cooperative dialogue to ultimately document it and issue a written determination to the individual as to whether you can make an accommodation or not. So are you required just to accommodate any employee who is under, say, medical marijuana to have them continue to work? Not necessarily. It all depends. And this is a very sensitive place. There's a lot of gray areas here. And we want to avoid any potential liability under claims under the Americans with Disabilities Act. So I strongly suggest you have an issue, something comes up, consult with somebody like ourselves at PMP on the HR consulting side or an employment attorney who knows about these rules to make sure that the actions that we are taking, the interactive dialogue that we are having with the employee, the documentation and a final written determination abides by all of the laws. So let's finalize and talk about some takeaways. Think about including a statement on your employment application if applicant drug testing is a requirement. Very few of you should have this on your, unless you're a federal contractor. Ensure your employee handbook is very specific as it relates to your practices. It's really important, and at the least, have a reasonable suspicion test. We can very easily help you with this. Train your managers on how to identify articulable symptoms and what do they need to do? What are the steps they need to take? If they see John first thing in the morning not acting kind of right and smells pot on them, they're not there to address it at 4 o'clock in the afternoon. We have to take care of it right away. Yes, I know the jobs are starting. Yes, I know all the equipment's coming in. Yes, I know all the supplies are coming in and everyone's yelling to get the job done. But you cannot take a chance on being known, on it being known that you were aware that somebody was under the influence. You let them go to work and God forbid that individual gets hurt or hurts somebody else. I wouldn't want that on my shoulders, and I know none of you want that on yours. You work and you reinforce safe workplaces 100% of the time. Learn how to apply this interactive dialogue that's required under the ADA and the New York human rights law. Treat all employees consistently. And what does this mean? You know, I know we have some employees who are just better than others, and I want to give them a little bit of leeway. But if you don't treat them as consistently as those employees who you don't like as much, you're going to wind up having a problem. And that's what leads to discrimination claims. Confer with your insurance carriers to manage your risk regarding employees who drive personal or company vehicles during work hours. Just have the conversation and understand how anything can apply and affect you. And ultimately, the less subjective the criteria, the easier it is going to be to defend. So I'm going to end where I started. Alcohol is legal, but an employee can't come to work drunk. In New York State, marijuana is legal, but an employee cannot report to work high. Let's see if there are any questions, which I am happy to respond to. Any questions verbally, in writing, in the chat? Collier, do you see something that I'm not seeing?
No, it doesn't look like we have any questions right now, but if you do, please type in the Q&A or you can click raise hand and I can unmute you.
as you're typing in your questions, I hope this has been informative and helpful. My email address is at the bottom of this list. Many of you have my phone number. I'm happy to share that as well. 516-921-3400. I'm going to put together a quick sheet on this information as well as the links that I referred to in the presentation. I'm going to send that over to Collier so this way she can get it to you and you have it as a resource. I want to thank you all very, very much, everyone. I very much appreciate your joining us today. I wish you and your families continued good health and a safe workplace.
Oh, Barbara, do we have time for one question?
We sure do.
Great. The question was, if somebody was tested, say, on Monday, because they had showed symptoms of being under the influence, and then they were tested, how do you know if they are testing positive because they were high at work, or they could have done it over the weekend and that wasn't it while they were at the job? Like, if the technology isn't there to differentiate, how do you know?
And that's very much the challenge. And until that test is developed, that's going to show us just like an alcohol test. You're not really going to know. Well, here's the situation. Can you take an adverse action and fire that individual? Sure you can, because you saw the articulable symptoms. You had a reasonable suspicion that somebody was under the influence, and you have a test that is supporting that. It's not as if it's the other way around where you had a positive test result and you're looking for the behaviors. You had the behaviors first. So let me throw it back and ask a different question. Let's say, for example, you were aware that an individual had these articulable symptoms, and you did the drug test. It came back in 36 hours that it was positive. And let's say we just slapped the person on the hand. And the following day, the employee comes back to work and gets into a very bad accident and there's a death. What's the Daily News going to say? Oh, maybe Newsday? What are the other media that we have to worry about? So I think if we take a no tolerance policy across the board, do it. But that first step has to be my observation of a reasonable suspicion that somebody is under the influence. I hope that helps.
Great. And we have actually a couple other questions that have filtered in. One of them was asking about specifics. I'm guessing specific verbiage to include in a employee handbook or something like that.
So let me address that one first. If you'd like us to help you with an employee handbook or even just this policy, please reach out to me directly. Next, I see Justine is asking, is there a level of marijuana that is unacceptable if the employee was tested under suspicion? I don't know. Right now, they don't know. They don't have that test yet. Now, I've heard and I've read a couple of things that there is a test out there, but it's really going through a lot of testing with the police departments across the country or in certain locations. So they're not ready to talk about it and present it yet because the test is being tested. So right now, we don't know what that level of marijuana is. Should you have the disciplinary actions? Another question from James. Should you have a disciplinary action specifically listed as to what will be done should an employee refuse to take a drug test? Yes. And in the policies that we write, we talk about if an employee refuses to take a drug test, it's going to lead to termination of employment. Because what chance do you want to take? I was at a job site in New Jersey, and I know it's not New York law, but let's say I was at a job site and there was a warehouse and there was reasonable suspicion that one of the individuals was under the influence of pot. And you smelled it all over him. A number of people did that. We said, you're going for a drug test. He said, absolutely not. We said, we need you to go for a drug test. He says, I refuse. He got into his car and drove away. We called the police, told them what car that it was, and asked that he be pulled over because our concern was that he was going to hurt somebody else. He was then subsequently fired. What other questions do we have?
Okay. If any questions do come up after the presentation, if you click out and say, oh, I should have asked that, Barbara's email is listed there, so feel free to shoot her an email. You can also email me and I can pass the question along too. But I do want to say thank you so much to Barbara for a really great presentation, and thank you to everyone for logging on. And I hope you all stay safe and be well.
Thank you, everyone. I wish you a great day. Be well.